protest be labelled as terrorism? How Supreme Court has gone ahead and redefined terrorism in the Delhi riots case, and how this changes the meaning, especially in the Unlawful Activities Prevention Act. Every democracy protects its right to protest, but the state also has the right to protect its security. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and today we are going to understand that how come a bail hearing turned into a better explanation, widening of UAPA and definition of terrorism within it. So let us start with understanding that how come we are discussing this bail hearing as something very important in terms of jurisprudentiality. So when we are talking about this particular bail hearing, we got to see that Supreme Court went ahead and denied two particular individuals the bail, but the others were granted the same thing. And in this context, court also went ahead and made sure to explain that all accused are not set on equal footing. We will be discussing this part in detail. Furthermore, another important thing that came in here was that this order went beyond bail and it reshaped that how terrorism is understood, especially when we are talking about Unlawful Activities Prevention Act. Now, this is where this case becomes a very important case study also and a reference point to understand that how anti-terror laws would be interpreted, how bail jurisprudence can change, and how Supreme Court has approach over it, and most importantly the debate about civil liberties as well as the national security around it. So let us start with the main order that has come through, and moving in there we need to understand that why specifically Section 15 of Unlawful Activities Prevention Act and how does it define terrorism and what has been changed or expanded. So when we are talking about Terrorist Act as per UAPA, it says that it is any act that threatens integrity, unity, security, sovereignty or the economic security of our country, or if there is a strike of terror in people or section of people that is happening. But when we are talking about how this is happening, how this activity is done, in this particular act, the means are also listed. What means are listed? Usually it is the bombs, explosive, firearms, inflammable substances, and Parliament has gone ahead and also used a statement where it says it could be by any other means whatsoever nature. Now this was the point where Supreme Court brought in the clarification, because the historical understanding of this statement was the focus is on violence being created or any kinetic instruments being used, and this is where we got to see the core interpretive dispute. That means if there is any other mean, does it include action, does it include incitement, and that's where the Supreme Court brought the clarification. Now when we talk about this particular clarification, we have to understand that the court went ahead and clearly rejected the similar means interpretation, where we are seeing how this particular terrorist activity is being done through only kinetic instruments. That similar means interpretation was rejected, and they clarified that if Parliament has written this particular statement and it has an open-ended language, then it is important that we go into the real interpretation here. So when we are talking about any other means, we cannot just stick to the narrow understanding of it. And that is where the key judicial interpretation and the shift was marked, where it was highlighted we can't just focus on the instrument, but we need to look into intent also, design also, and what effect can be created by that activity. So this is where we get to see that terrorism is no longer being confined to any sort of just weapon or some sort of physical activity. Rather, the focus is on what kind of impact it is creating, not just economic, not just physical, but also societal. and how it destabilizes the potential of the nation, the potential of the people or the society. Now, one question that arises in whole of this debate, that why specifically court went for intent and not any other mean here. So, when we are talking about the court's clarification here, the court clearly said that when we are talking about terrorism, it is defined by purpose and it cannot be understood when we are just looking at the instruments. We have to look into the intent as well. So, when we are talking about the Delhi riots case, in which context the bail hearing was happening, in that particular riot case, when we are talking about the coordination, the strategic timing and the idea to paralyze civic life, it shows that there was a clear intent to disrupt and have a societal impact. So, in certain scenarios where there might be supposed non-violent acts which can become a terrorist activity if they have a design which is inherently destabilizing, which has a huge social impact in a negative way, and this is where we are marking this as a landmark jurisprudential evolution, because we are placing the mental element above just the physical activity. Just the intent has to be taken into consideration, the effect has to be taken into consideration, and also the design of it to what impact would have been created. And as a result, we are going to see that ordinary acts which are present, they might acquire terrorist character through just this intent. Now, the good part here is that it does strengthen the national security perspective, but something to think is when we are talking about normal acts or regular activities or protests, they might be labeled as a terrorist activity if we are just looking into intent. So, when we are talking about understanding terrorism, which is a multifaceted problem originating from multiple sources, we also need to keep in mind that we cannot discard away just to focus on intent. It needs to be a wholesome understanding where we ensure that ordinary acts which are not associated with terrorism, they remain separate, and the rights of an individual, rights of the organization, they are not subsumed in the power or the security of the state that we are talking about. Now that we have some fair clarity on what exactly has been said, what exactly has been explained by the court, and what expansion of definition has been done, now let us move to understand wider implications, starting with the most important one in terms of Article 21. Okay. So, when we are talking about Article 21, that is right to life and personal liberty. In this context, when you talk about this particular act, that is Unlawful Activities Prevention Act, in this context, you have to understand there is long incarceration which is involved, and they are slow and stalled trials. So, when we are talking about the individual personal liberty, this is where it stands compromised if the person who is being accused is actually not responsible for this. And as a effect, we get to see that punishment comes into the scenario way before the conviction happens, again violating this very fundamental right in itself. Furthermore, in this context, court has went ahead and clarified this particular stance that national security is the main concern which outweighs the liberty at the bail stage. So, the main conversation that we started with, that civic liberty versus the national security debate, this is where it gets heightened. And especially from the perspective of your exam, this becomes important because you have to understand the tension that exists between the due process and also the preventive detention logic that exists in our constitution, and how this needs to be balanced, especially in the longer run, to ensure that the key points of our constitution are not compromised. The public, their liberty, their rights are not compromised, but at the same time, we are not letting go of national security. Now, in this context, when we are talking about Article 21 itself, it becomes important to understand Article 19 as well, that how did the court balance Article 19 and the freedoms along with it, especially with security, because court, which is the apex in this whole order, will make sure that yes, national security stays at the primary place, but at the same time it will not be the place which will sacrifice the fundamental rights and freedoms that come along. So how did they balance that? They balanced it by clarifying that how the protest, yes, is a fundamental right, you have the right to protest, but it loses the protection that the constitution gives it once it enables the paralysis of urban governance, once it provokes violence or threatens public order. The moment protest is going in this direction, this is where the protection that they get under Article 19(1)(a), Article 19(1)(b) as a legitimate democratic protest, it just goes away. So court clearly went ahead and talked about reasonable restrictions that we have in place under Article 19 itself, and even after clarification, it yet again pointed us towards to a point where do we understand that protest ends and it begins as an act of terror. Now at this particular point, I would ask you to add in your points of discussion in the comment section, that how do you feel that this core constitutional dilemma can be addressed, that how the balance between the civic liberties and the national security should be maintained. Because when we are talking about this particular order in itself, one thing we get to see as an impact, that it has went ahead and broadened the understanding of internal security. Because when we talk about terrorism model, traditionally we got to see that there were presence of armed groups and also cross-border violence. But if we look at this new judicial recognition, it easily brings in urban unrest, psychological terror, mass civil disruption in this very definition of terrorism and as an internal security threat. And when we are talking about expanding the security lens, it is not just about identifying what can go wrong, what is the threat, it is also about how to address that. So this is where we look up to the executive, we look into the governance, that how these problems can be solved, because the security lens has gone beyond kinetic instruments, it has gone beyond the physical parameter. So it is talking about non-kinetic threats, it is talking about social impact, but the question is how it needs to be addressed. This should be the next step in this direction, while keeping in mind that we do not over-securitize, especially dissent, and make sure that the extended scope of this definition is not misused. In the end of it, yes, we have to understand this broadened legal meaning of terrorism, but this has brought two very important things to light, that terrorism is not going to be limited only to kinetic and physical things. It will have intent, social impact involved, and it will have broader effects. Furthermore, it has also highlighted that how bail under anti-terror laws is exceptional. It cannot be treated like a random law, and this judgment again highlights that how there is tension between national security and civil liberties. It was from the day one the constitution was made, and this could not have been diluted till date. But still it becomes very important from the perspective of exam, because it is a very important precedent in terms of how protest and internal security will be legally assessed, understood, especially in the future. And this also might be the time that we are seeing a turn and tilt excessively towards national security more than civic liberty. What are your thoughts on this? Let me know in the comment section. That was all from my side. Thank you so much.